So based on the current situations, today's topic will be more relevant. It's a common question that force measure does not automatically cancel liquid damages. How? So what is a myth in industry is that the force measure automatically gives the leverage for the contractor to claim the EOT or for the liquidated damages, which is a myth and which is not reality. See, the legal interpretations and contractual entitlement with the reality of different. So let's see how it works. Contractual position is force measure is not equal to automatic LD relief. You may even take standard forms of contract like FDIC or even international standards like Society of Construction Law Delay and Disruption Protocol. It very clearly says that the force measure can give performance obligation not to be done under the contract. So it gives a relief and it gives an entitlement to EOT. And cost entitlements are only limited in certain circumstances, such as damage on the direct construction site or damage on the materials, so on. However, the liquidated damages are governed separately by the delay damages provisions, usually the UOT classes 8.7 or 8.8, depending on the edition. There is no automatic contractual linkage between the LD and force measure. The critical link between both is the extension of time. So LD exposure is limited only when the time of completion is extended. So LD applies when delay exceeds contractual completion date. If the UOT is granted, the completion date is shifted and LD may not apply. So force measure protects against LD only if it is results in a proper granted yield. Now, how this EOT has to be claimed and what are the places the contractors go to? The first assumption is notification is equal to protection. So we have submitted a notice of force measure and even though if there is a delay in the project, the employer automatically understands that there is an EOT and we use an extension of time, which is not true. So what the reality is that the contractor has to explain detailedly what is the delay impact and how it is linked with the program and how it affected the critical path. And then he has to apply for the EO. Till then, the LD is true. Second scenario, failure to demonstrate the critical path. So they will say that the force measure has affected project, we are not able to perform and we are not able to get the delivered on the project completion. If the force measure did not affect the critical path of the project, then it will be very difficult for the contractor to get entitled for the. So, how to demonstrate that the force measure has affected the critical path? First, the war disrupts the material supply, but contractors had float or alternate sources. Then the contractor cannot prove the criticality of the war disruption. So no EOT LD remains applicable in this scenario. Scenario 3, poor record keeping. So if no contemporary records is equal to B completely. Typical failures are no daily logs, no procurement disruption evidence, no revised program evidence. These has to be made. See, for example, if you are procuring from different parts of the countries and it's being held up at the Strait of Hormuz, then you should at least have, see, our ships has been held up there for a long time and the container has a barcode or the details, the airway bill or the bill of lading should say that material was ready long ago, but the logistic was the issue. You just can't come and say that if the manufacturing is delayed and you cannot take the cover that the Strait of Hormuz has fixed. That's not so. So where employees misinterpret the question. So employees often reject the force majeure claim outright, which is not right, and they continue levying LD without assessment. This creates exposure under the prevention principle. If the employer's action or the risk events allocated to the employer prevents completion and no EOD is granted, LD clause may become unenforceable. So the legal layer, the prevention principle interaction. So under common law jurisdiction, if employer prevents the completion or employer risk event prevents the completion and no EOD mechanism is properly applied, time becomes lapse. LD cannot be enforced. The contractor is liable only for general damages, often ordered to prove by the employer. So force majeure events, if contractually allocated risk, can trigger similar consequences if mishandled. So the employer has to handle it in a very right way. We have given a separate video on the employer strategies and the force majeure, how to handle the negotiation, where they should focus, how to bifurcate the issues which are clear issues and which are gray issues and which are the issues that has to be rejected upfront. Concurrent delay complication. See, one of the most disputed areas force majeure event occurs. The contractor is already in. So whether how to handle this, whether the contractor delay push the entire project to get into stuck with the force majeure, or the contractor delay started with the delay of the force majeure, there are different scenarios which has to be done. So the key question is LD relief still applicable? That is the title of this presentation. So what are the positions? The contractor usually expects that we need the full EOT and no LD. The employer says they don't know. It is a concurrent delay for a certain period. For that, you are eligible for EOT. For the balance delay made by you, the LD is still applicable. So what does SCL say? Society of Construction Law says EOT may still be granted for employees rescuable, but cost entitlement may be restricted. Cost entitlements are very limited under force majeure conditions. So practical scenarios. Let's see some of the practical scenarios. Whatever happens. For example, scenario 1. The war-induced supply chain disruption. The contractor invokes a force majeure clause, but it fails to demonstrate the criticality of these materials in the project. For example, at the starting of the project, the material delivery might be critical. For example, you are doing a pipeline project and critical walls will fall under the critical path. And you are focusing on the walls and you say that the walls are delaying, so it affects the critical path. But if we say that at a particular point of time, the walls might be in the floor or the near critical path, which is the construction of the control room, got delayed. Construction of the control room has no linkage with the wall bill. In fact, the control room must be ready to install the wall bill. So the employer may not agree that the wall delay doesn't affect you because the near critical path became the critical path. You didn't focus on that, which is fully under the control of the contractor, and that the wall delay doesn't play any role, and you are not getting a coverage under force majeure. This is an example. Scenario 2, let's say that's a pandemic law. The proper notice is issued, program is updated, critical path delay is proven, yes, EOT is granted. If you follow all these steps as a contractor, you get you. Scenario 3, force majeure plus contractors inefficiency. This is the most debated area because the mobilization will be less, the efficiency of the contractors' performance, like productivity, will be less, and this joins with the force majeure. How to handle this? This is a very, very niche area which has to touch actually the disruption analysis. But here we are focusing on delay analysis and the delay party due to the contractor mismanagement. So for this, if we are able to prove as an employer that the productivity is less when compared to the measured miles, then partial EOD can be handled and residual LD exposure remains. So strategic approach for the contractors. So what are the contractors to do? To neutralize the LD risks, notice is a non-compromise matter. You issue the notice. Demonstrate the causation, not just the actions. Somewhere the war happened, somewhere a drone occurred, doesn't put you in an entitlement under your group. So how you are affected? So link the event to the activity and the activity should be linked to the critical path. And the critical path has to drive the delay. Dynamic program updates. See, that's what I said, that we have to keep updating the program because the critical path updates. So using time impact analysis, assign with baseline and updated schedules. Maintain contemporaneous records like site logs, supply chain disruptions, correspondence, everything you have to. Separate EOT and cost claims. Do not assume both will succeed together. So EOT itself needs so much of entitlements to be demonstrated. The quantum needs a different kind of demonstration. Strategic approach for the employees. So preserve LD enforceability, enforce strict claim record. So they have some of the notices, evidences, programs, all should have their linkages. Avoid blanket rejection access. So please avoid that we reject your EOT. Please don't do that. That is not a proper way of assessment. You are an engineer, you are an expert who has to assess the delay and then respond. Issue determinations. Timely delayed decisions weakens LD enforcement. Monitor concurrency carefully and differentiate the contractor's delay and force majeure delay, which is going to be a bit difficult, but it is possible. So what are the insights for drafting insights for future contracts? So if clarity is required, contract should explicitly state whether LDs are automatically suspended during force majeure. No contract will say that. So write this very clear. Whether EOT is mandatory or discretionary. Treatment of concurrent force majeures delays along with the contract delay, along with the employee. So in EPC projects, ambiguity leads to the disputes. The bottom line is force majeure is not a shield against the liquidated damages. Extension of times. So without securing extension of time through proper contractual mechanism, LDs remain enforceable. Claim weakens significantly. Dispute becomes ineffective. So the closing line is single. Don't do an event-based thing. Do an entitlement-based demonstration. And for employers, don't go with the rejection mindset. Our goal is to achieve the program or the project delivered on time at the high quality, and it should be useful for the society. So always think in the shoes of the contractor and try to mitigate what can be done and sit with them and speak to move the project forward even under this stress situation. A teamwork can definitely break all these negative things which is happening right now in the world. We have to stay positive as a construction engineers and we have to move because every situations which we have seen before has always normalized in a shorter period of time. So we have to hold till then and keep pushing the progress of the project forward. Thanks for watching. We'll meet in some other videos. Next, and if you want to meet to talk about any special videos, please drop your email. Thank you. Bye.